Not recently.
I'll take a chair while you ask her. Yeah, we'll put it back. Don't tell her yet. Oh, no, we won't. We'll give you a minute. She said, don't tell her I'm here yet.
Nice communication. Did she tell me?
We know that. Hi, how are you? Fine, how are you? Good. Hi, he's in Grand Prairie and Tim left for the day. Very nice. So I understand, like, they're upstairs and I'm waiting for two. I'm like, okay, what? Thank you. Nice to see you. Seated. Good afternoon, Carrie.
Good afternoon, how are you?
Good, how are you?
Good.
Right. We're here on several matters. The first is case 576-419, and that is an outstanding indictment with respect to this defendant. It is my understanding both the state and the defense have entered into an agreement about that case. Is that correct?
It is, Your Honor.
It is.
All right. And that case number, as I indicated, is 576-419, and the charge on that is a failure to register. Is that correct on behalf of the state of Ohio?
Yes, right.
All right. And could you tell me the code section, please?
Your Honor, it's correct. It's a failure to provide a notice of change of address.
Thank you. And could you tell me the code section, Mr. Grant?
Yes, it's 2950.05, subsection F, subsection 1.
And that is a felony of the second degree, is that correct?
That's correct.
All right. And is that your understanding on behalf of the state?
It is, Your Honor.
And it is further my understanding that the state and the defense have agreed that there would be a plea in this count or this case, and that the state and the defense are recommending to this court that there be a concurrent sentence with anything that is on the underlying offense for which we are here today.
That's our understanding, Your Honor.
Is that your understanding?
True, Your Honor.
All right. So, Mr. Madison, I'm going to ask you a series of questions. Please answer out loud. How old are you, sir?
38,
How far did you go in school?
9th grade.
Are you now under the influence of any drug or alcohol?
Not at all.
Are you an American citizen?
Yeah.
Are you on probation, community-controlled sanctions, parole, or post-release control?
No.
Are you satisfied with the representation of your attorneys?
No.
And could you tell me why you're not satisfied?
I really don't care to.
Well, sir, I cannot take your plea unless you provide me with some information, or I cannot proceed in any way unless you either are, number one, satisfied with the representation you've been given, or indicate to me why you are dissatisfied. Are you choosing not to do so, sir?
No, I'm not choosing not to do so. I just have to say I'm satisfied then.
You are satisfied? Sir, I want to make sure that you are satisfied, because if you're not, we can set this for trial, and we will have a trial on this case. It is your choice. You can enter a plea, or you can have a trial. What would you like to do, sir?
We talking about on the failure to address?
Yes.
Yeah. I'm satisfied.
You're satisfied with your lawyers, is that correct?
Right.
All right. Now, do you understand that by entering a plea of guilty, you're giving up certain constitutional rights?
Right.
Do you understand you have the right to a trial by jury? Or you could let me finish the question. Or you could waive that right and try your case to a judge without a jury.
Right.
Do you understand you have the right to an attorney, either when you hire yourself, or if you can't afford one, when the court appoints for you, at no cost to you?
Yes.
Do you understand you have the right to subpoena witnesses to appear at trial and testify on your behalf? And that means if you wanted a witness to come in and testify for you, but they wouldn't come in voluntarily, you could use a court subpoena power to make them come in and testify.
Yes.
Do you understand you have the right to confront and cross-examine witnesses?
Yes.
Do you understand you have the right to have the state of Ohio prove your guilt by evidence beyond a reasonable doubt?
Yes.
Do you understand you have the right to remain silent and not testify? And no one could comment on the fact that you did not testify at trial.
Right.
Do you understand the offense to which it's proposed you're going to plead, as well as the potential penalties?
Yes.
I'm going to review it with you, sir. It's proposed that you are going to plead guilty to 2950.05, notice of change of address. And that is a felony of the second degree. It's punishable by 2 to 8 years in prison, a fine of up to $15,000 or both. Do you understand that?
Yes.
Now, your sentence could be served concurrently with whatever sentence I'm about to give you, or it could be served consecutively, which means after you finish the sentence for the aggravated murder and other related offenses. Do you understand that?
Yes.
Do you understand your lawyers and the state's lawyers have recommended to me that you serve that term concurrently, which means at the same time as the time that you are about to receive on the aggravated murders and the other related offenses. Do you understand that?
Yes.
Now, do you understand, upon your release from prison, you shall be subject to a 3-year mandatory period of post-release control?
Yeah.
And do you understand if you violate post-release control, the parole board has the authority to impose up to 1/2 the original sentence imposed?
Yeah.
And finally, do you understand if while you're on post-release control you fail to report to your parole officer, you can be charged with escape, which is a felony?
Yeah.
Do you have any questions about your rights, the charges, the penalties, or anything that's being done here today?
No.
Have any threats or promises been made to you in order to induce you to enter into this plea?
Not at all.
Knowing all that I've outlined for you, how do you plead to notice of change of address in violation of 2950.05, a felony of the second degree?
Guilty.
Let the record reflect, I find that you've knowingly, voluntarily, and with the full understanding of your rights under your change of plea. I accept it and make a finding of guilt. On behalf of the state of Ohio, are you satisfied I've complied with Criminal Rule 11?
State satisfied.
On behalf of the defense?
Yes, sir.
All right. And now, I want to outline the procedures that we will follow today with respect to the sentencing. And that is the sentencing in, excuse me 1 second. Would you mind pulling it up? That's what we just did. Sure. Okay, thank you. And now we're going to proceed to the sentencing in case number 579539, the state of Ohio versus Michael Madison. We will proceed in this fashion. First, we will have the sentencing on the capital offenses. And then by law, we'll have a separate hearing on the non-capital offenses. Representatives of the victims' families are only permitted to be heard at the non-capital sentencing hearing. So you'll have an opportunity to present those people at the appropriate time, all right, on behalf of the state. And so the next thing we have to address is counts 1 and 2, which relate to the death of Shetisha Sheeley, counts 4 and 5, which relate to the death of Angela Deskins, and counts 7 and 8, which relate to the deaths of Shirrellda Terry. I find that they merge. 1 and 2 merge, 4 and 5 merge, and 7 and 8 merge. the state must elect at this time which counts you would like to have the defendant sentenced.
Mr. Shirrellda will address it.
Thank you, Your Honor. The state will elect to proceed on count 1, aggravated murder of Shetisha Sheeley with prior calculation and design. On count 4, aggravated murder of Angela Deskins with prior calculation and design. And count 7, aggravated murder of Shirrellda Terry with prior calculation and design.
All right. Does the defense wish to be heard on that?
No.
All right. And so at this time, I will hear from one or more of the defense attorneys relative at this time to the capital offenses only.
Thank you, Your Honor. Please, the court. I believe the court has received a sentencing memorandum.
I have, yes.
So I'm going to highlight some areas of that memorandum. If it's all right. We certainly can't dispute the reprehensible nature of the conduct for which Mr. Madison was convicted. But we submit, Your Honor, that imposition of death here will not bring back any of these young ladies and will not return them to their loved ones. We believe the evidence throughout both phases of this case showed that Michael Madison's upbringing virtually from birth was a product of abuse by both his mother and a series of abusive live-in boyfriends, as well as a family tree that was fraught with emotional, physical, and sexual dysfunction. I would submit, Your Honor, that not one person in this courtroom would allow their child to spend one night in the household that Michael Madison grew up in. You've heard through the course of this trial the testimony concerning children and family service records. We certainly outlined the type of abuse he suffered. And I would submit, Your Honor, would be naive to believe that these records represent anything more than a small percentage of the total abuse that he was subjected to during his formative years. I would also submit, Your Honor, it would be naive to believe that this abuse suddenly stopped after a couple of years. And that's certainly contradicted by the record of abuse going forward suffered by his brother who lived in the same household, who again was subjected to repeated abuse over a period of a number of years beyond the termination of some of the service records or family service records relating to Michael. Your Honor, we believe that his history of abuse and dysfunctional upbringing certainly doesn't excuse what happened here, but certainly provides a basis for understanding the type of person that Michael Madison evolved into. Your Honor, it's true that many people grow up in abused backgrounds and don't go out and commit multiple homicides. However, Your Honor, I would submit that amongst those who end up doing that, a common thread is the type of abusive background that Michael Madison, abusive dysfunctional background that Michael Madison was raised in. We heard from a respective corrections individual as well as a forensic psychologist that indicated to this court that Michael Madison is not a threat to staff or other inmates in a prison setting. And they certainly clearly indicated that the best indicator of what one's adjustment will be in prison is looking at past adjustment to prison as opposed to their conduct on the streets. And both of these individuals will find that he's not a threat in that regard. Your Honor, despite Michael Madison's character flaws and emotional issues, he loved his children, and his children loved him. And we would submit that imposition of the death penalty, amongst other reasons, in this case, would simply create two additional victims in this case. That being his children, who had nothing to do with any of this, will certainly be without the loss of their father. We would urge this court to find that the aggravating circumstances in this case do not outweigh the mitigating factors beyond a reasonable doubt and impose a sentence of life without parole. Life without parole in this case, Your Honor, will permanently incapacitate Michael Madison, remove him from society permanently, and permit him to still potentially have a productive life behind bars, or perhaps it can be a benefit to someone in the long run. Again, Your Honor, we believe that the life without parole is the appropriate punishment here, based on all the factors that were brought forth during Phase 1 and Phase 2. We believe that the mitigating factors presented do carry significant weight, and they should be viewed equally, if not greater than, the aggravating circumstances presented by the state of Ohio during the course of this trial.
Mr. Madison, what would you like to say before sentence is imposed?
Nothing.
On behalf of the state of Ohio.
Thank you, Your Honor. The state did file a sentencing memorandum this morning.
I read that. I received it and read it. Yeah.
Thank you, Your Honor. I'll just reiterate some of the points from that. As a matter of law, the Ohio Supreme Court has addressed many of the mitigating factors and the aggravating circumstances that are at issue in this case. I refer this court to State v. Hutton, 100 Ohio State 3rd, 176, at paragraph 91, quote, "The revised code 292904A5, multiple murder aggravating circumstances, carries great weight in aggravation." And in addition to that specification, Mr. Madison was also found guilty of 4 felony murder specifications, 3 kidnapping specifications, 1 for each victim, and a rape specification for the mutilation of Shirrellda Terry's body while she was still alive. Those things are all entitled to additional weight. By contrast, the mitigation that was presented in this case is very slight when viewed through the lens of the Supreme Court's pronouncements on this area. In State v. Murphy, the Supreme Court held that a defendant's dysfunctional upbringing is, quote, "entitled to some weight, but we have seldom accorded strong weight to a defendant's childhood." And State v. Murphy is 91 Ohio State 3rd, 516, page 547. I'd also refer this court to State v. Hale, 119 Ohio State 3rd, 118, paragraph 265. Quote, "Hale spent significant portions of his childhood in an unstable environment, but we have seldom given decisive weight to this factor." Additionally, Mr. Aiken's testimony that Mr. Madison could be successfully housed in prison for the remainder of his life with little risk of violence is entitled to very little weight in mitigation. The Supreme Court held in State v. Smith, 80 Ohio State 3rd, 89, page 121, that evidence that a defendant adjusts well to prison is entitled only to, quote, "slight mitigating weight." So because the Supreme Court has addressed these factors and held that they are not entitled to significant weight in mitigation, this court should grant them that slight mitigating weight and find that the aggravation easily outweighs any mitigation beyond a reasonable doubt. I'd also point out that a sentence of death will definitively end the murders of Michael Madison. It will send a message to the community that the strongest possible sentence will be imposed upon crimes of this nature, and it will have a deterrent effect, as the Supreme Court recognized in the Gregg case, that will stop others from committing these kinds of crimes in the future. Thank you.
On May 20th, 2016, the jury unanimously recommended the sentence of death as to all the capital offenses. As required by law, I independently weighed the aggravating circumstances against the mitigating factors. The aggravating circumstances are as follows. 1, course of conduct. That the aggravated murders were part of a course of conduct involving the purposeful killing of 2 or more persons, namely Shetisha Sheeley, Angela Deskins, and Shirrellda Terry. This multiple murder is afforded the greatest weight. 3 separate murders were committed over the course of 9 months, all similar in planning, site, and means. Secondly, the felony murder, kidnapping. The defendant deceptively lured all 3 women to his apartment. Also, each woman's liberty was significantly restrained so that the aggravated murders could be completed. This aggravated circumstance is similarly afforded great weight. 3, felony murder rape. The defendant used an unknown instrumentality to violate Shirrellda Terry, causing mutilation to her genitalia. This aggravated circumstance carries great weight as well. The mitigating factors which are to be weighed are as follows. 1, adaptability to prison. Although prison expert James Aiken testified that the Ohio prison system could adequately handle the defendant and that he could adapt well to prison and that he might be able to provide in some minimal way some kind of productive life, this factor is accorded minimal weight. 2, substance abuse. Although not argued this afternoon by Mr. Grant, it was throughout the course of the trial. Evidence was introduced that the defendant's abuse of alcohol and marijuana impaired the defendant's choices and behaviors. No reliable evidence was introduced that he was significantly under the influence at the time of any of the aggravated murders. His free choice to abuse substances is afforded very slight weight. 3rd, defendant's relationship with his children. At the conclusion of the penalty phase, in defendant's closing argument, 2 photographs were shown of the defendant with his 2 children. There was no testimony considering these photographs, and they were not sought to be admitted. There was minimal testimony concerning the defendant's interaction with his children during either phase of this trial. This factor is given no weight. 4, the defendant's background. It is quite clear from the testimony of both phases that the defendant had an extremely difficult childhood. He suffered greatly at the hands of his mother, her partners, and extended family. He was abandoned by his father. He was exposed to drugs and inappropriate situations. His background is given greater weight than the others, but only marginally. It is not given great weight. There was nothing mitigating in the nature and circumstances of the aggravated murders. The court did not limit its consideration to the specific mitigating factors found in the Ohio Revised Code or the specific mitigating factors argued. Rather, the court considered any and all mitigating factors which were supported by the evidence. In weighing the aggravated circumstances against the mitigating factors, the other offenses of which the defendant was convicted were not considered. The mitigating factors were weighed both singularly and cumulatively. Upon consideration of the relevant evidence, the testimony exhibits admitted in mitigation, it is the judgment of this court that the aggravated circumstances of course of conduct, felony murder, kidnapping, felony murder, rape, of which the defendant was convicted, outweigh the mitigating factors by proof beyond a reasonable doubt. Accordingly, the sentence of death is imposed upon the defendant, Michael Madison, on counts 1, 4, and 7. We will now move to the sentencing on the non-capital offenses. The defense attorneys may speak again if they wish to do so.
Yeah, we simply reincorporate the arguments we previously made as to these counts, and also indicate that Mr. Madison again will assert his Fifth Amendment privilege, which is for the extension of the sentencing process.
But I am required to inquire of him on the record if he wishes to make a statement. And so, Mr. Madison, at this juncture, is there anything you would like to say to this court before sentences imposed on the non-capital offenses?
Not at all.
On behalf of the state.
Thank you, Your Honor. We have several family members that would like to address you at this point, and then the state will address you in the end. On behalf of Shetisha Sheeley's family, Samara Sheeley has written a letter to you that's going to be read by our victim's advocate, Georgina Cohat, and her mother, Kametta Sheeley, will stand with her at the podium.
All right, and I also want to let everyone know that I have read the sentencing memorandums, and I did receive some letters that were forwarded to me on behalf of Ms. Terry's family, and I've read those as well, and I have them with me here in court.
Thank you, Your Honor.
Yes. Ma'am, I'd like you to come forward if you would, please. And could you please tell me your full name?
Shetisha Sheeley.
How do you spell your first name, ma'am?
K-I-M-M-E-T-T-A.
And your last name?
S-H-E-E-L-E-Y.
All right. You'd like to read a letter? And I need your name for the record as well, ma'am.
Georgina, G-E-O-R-G-I-N-A. Cohat, K-O-H-U-T.
Go ahead, Ms. Cohat.
Thank you. On July 13th, 2013, our family's lives changed, yet once again for the worst.
Ma'am, I'm just going to ask you to keep your voice up. Our court reporter has taken down what you have, and if you could speak slowly, please. Thank you.
We learned that we lost a sister, a daughter, a mother. Michael Madison took 3 lives, including my sister's, with no mercy nor sorrow. Not once have I noticed any regret written on his face. Instead, when I look his way, I see smirks and grins. You took the life of a little girl's mother. You never understood the void you've placed inside my niece's heart. No holiday or birthday will be the same. You will never know the look on a child's face when you tell them their parent is gone for good. Graduations, marriage, and life journeys will all be altered from the act of one man. Distant memories are the only thing we have to offer my niece. My sister was funny, full of life, and energetic, all wrapped up into one. She loved her family no matter the differences, never missed a bird, nor a holiday. She was the life of the party, walking in the room, ready to tell a joke. But you took that away from us. What or who made you decide my sister's life should have been taken? 3 families have gathered and united over the senseless act of one man. We had no remorse or regret for ruining the lives of 3 different families. So why should we have sympathy on you? For 9 months you made us worry, think and formulate stories as to where our loved one was. All along you had her tied up inside of a black garbage bag. If you get injected, you take the easy way out. Yet, if you sit in prison, you continue to think of the lives you've ruined. Not just the families of Shetisha, Shirrellda, or Angela, but also your family and your children. It's a lose-lose situation here, and it makes me think selfishly. Knowing that your family will have an opportunity to come and see you behind bars makes me want you to die. But getting the death penalty will only feel half the pain that you put those women through. I honestly wouldn't want you to ever get a chance at hurting anyone else ever again. So the best solution for you is to get injected and have this.
Thank you for coming down this afternoon, ma'am. You can have a seat again. Ms. Shirrellda?
On behalf of Angela Deskins, Marie Paget, and Linda Deskins are going to address the court.
Good afternoon, ma'am.
My name is Marie Deskins. Marie Paget.
That's all right. Take your time. Could you tell us your full name, ma'am?
Marie Paget.
And how do you spell your last name, ma'am?
P-A-D-G-E-T-T-E.
Thank you.
Standing here before you today is very, very difficult for me.
Take as much time as you need, ma'am. And Carrie, let me know if you can't hear her, all right? Thank
Your
you.
Honor, I think she wants me to continue.
You'd like Ms. Cohat to read it for you?
Yes.
Okay, that's fine.
Standing here before you today is very, very difficult for me. Being the mother of Angela Deskins, who was known to the family and friends as Angie. This is the same young lady whose life you so brutally took from us. From a baby, she always had a smile on her face. I miss her calling me and saying, "Hi, Mom." You took all that away from me. Angie was my baby. I brought her into this world, and you had no right to take her out as if she was a piece of garbage. I often think of those last seconds of her life and how horrific it must have been, and that you were the last person she laid eyes upon. When the media has their cameras on you, you have a smirk on your face, showing no remorse. But I tell you here and now, what you really need to be doing is praying and asking for forgiveness. You may have taken Angie from us physically, but she will always be with us here in spirit and love in our hearts. She will be our Angie forever. At the end of the day, no one has really won here. I'll never get Angie back. You took her from me, and I hope you have one piece in your heart and your soul, so that you will have to ask for forgiveness before your life is snuffed out. And there's a picture that I think is mine.
Please. Thank you. I appreciate it, Ms. Paget. Let me give this back to you so you have your daughter's picture. Good afternoon.
Good afternoon, Your Honor.
Could you please-
I'm Linda Deskins, Deskins.
Go ahead, what would you like to tell me?
I'd like to first thank you for your service to this court, providing the impartial and legal way to deal with, and I'm not saying this well, but anyway, thank you. And our thanks to the jury and to the prosecutors, and a short nod to the defense. For nearly 3 years, I planned to make a statement to this court. I've reworked it many times, but I started off feeling hate and a desire for retribution, and now I'm just interested in peace and justice. And I think justice is about to happen. 3 women were kidnapped, tortured, murdered, and then their bodies were defiled and treated as trash. These women were loved and appreciated. Their company was desired by their families. We lost the ability to enjoy their smiles and laughter, sometimes their anger and their frustration. Our holidays and birthdays and celebrations will never be the same now because they won't be with us. Children have been born in our family who will never know their aunt. We families have lost our daughters, our sisters, our cousins. One lost a mother. We survivors have almost lost our minds and our peace of mind and the ability to sleep or to enjoy a meal with the loved ones we still have because we focused on our girls' suffering and the disrespect that they were given after they were dead. I met Angie when she was 4 years old, and somewhere between her being 4 years old and coming to live with us, her dad and I, when she was 7, she became my daughter too, and she always has been. And the last time I spoke with her, she called me on Mother's Day, shortly before she died. And I was so happy to hear her voice, and I told her how much I loved her, and I couldn't wait to see her again. That didn't happen. We family members have tried over these 3 years to cope by using excessive amounts of alcohol in some case, by using antidepressants to help us get through our days. Angie died, but our lives were crushed also. I've seen my husband walk through life as though he wore shoes made of cement. It was so hard to get through one day after another. And nothing that anybody could say or do could make it better for him. When we first turned out what happened to Angie, it was like we'd been punched in the gut. We felt so much pain and so much overwhelming sadness. And then you wait for the body to be released by the morgue. And then there were the visits to the funeral homes, trying to make a fitting choice on how to honor our daughter. We had to have a closed casket, of course. And I debated whether or not to say this, but I'm going to. I thought it was just such a strange twist of fate that we had to choose clothing for her to wear in her closed casket. But we did. It took 1.5 years after Angela was buried before we could face going to a company that provides memorials, the headstones and so on. It took 1.5 years to get that far. And after it was done and placed, it took another year before my husband could deal with going to the grave site to visit her grave. My husband has had cancer. About 1 year ago in March, he started treatments on his throat. He had radiation. He had stupendous amounts of pain. He still has excessive pain. But I am firmly convinced that he would gladly take that pain in exchange for one more day with Angie. Our oldest granddaughter wrote a poem for her beloved Aunt Angie that she read at a memorial service. And our youngest daughter was the family spokesperson following Angie's death. I don't know how she did it, but we are all grateful to her for having done so. Our sweet, funny, stubborn Angie is gone from us. She was loving, she was caring. We will all miss her forever. Nothing will bring back Angie, Shetisha, or Shirrellda. In my religion, I believe that when a person does wrong, they die and they come back in a lowly form. Maybe an ant or a fly to be swatted or stepped on. And then they come back again, maybe as an ant or a fly, maybe a little bit higher. And they go through this time after time after time until they do something that's good and they will be redeemed somehow. That's just my take on things. Our girls will live on in our hearts forever, but we can never forget how they died. And I thank you for listening.
Belinda Minor, and I believe Angela Gallagher. And Mr. Terry.
Good afternoon, sir.
How you doing, Your Honor? My name is Terry. Father Shirrellda Terry. Right now, I guess we're supposed to, in our hearts, forgive this clown. He's touched our families, taken my child.
Recess. Thank you. Justin, that was me hitting the panic button.
Fine. Do we need to clear a courtroom or what?
I think we're good. I think we're good, but it's up to you, Justin. You decide what you think is appropriate. Red, let me know, first of all, if the defendant is all right. And number two, if he's able to come back out at some point this afternoon.
Okay.
All right, thank you.
Okay.
Is your sergeant coming up, or should I be speaking to you in charge? Who's in charge?
You can talk to me right now. I don't know if someone is yet.
All right. I do. If you could stay
I'll ask him to leave right now. I'll be right back, Your Honor. I know. I'll be right back. I'm going to leave right now.
You don't accuse yourself.
Out here.
Yeah?
No, deputy.
He's out.
Go out there.
I'm looking for those somewhere in all these papers. I think one of my emails got mixed up. Just trying to see if I don't think it's anything important anyhow, but